I'll start with my speech. As chair of the Children and Family Law Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic, and in accordance with House Rule 67 and the governor's emergency order number 12 pursuant to Executive Order 2020-04, this public body is authorized to meet electronically. This is a public hearing on bills referred to the committee. An executive session may follow. Please note that there is no physical location for members of the public to observe and listen contemporaneously to this meeting. However, in accordance with the emergency order, I am confirming that all members of the committee and select legislative staff have the ability to communicate contemporaneously during this meeting through the Zoom electronic meeting platform, and the public has access to contemporaneously listen and, if necessary, participate in this meeting by the Zoom platform or by telephone. All necessary access information has been made available in the House calendar and through the electronic calendar on the General Court website. The notice for this meeting notice complies with House rules and RSA 91A. Anyone who has a problem accessing the meeting should call 603-271-3600 or email hcs@leg.state.nh.us. In the event the public is unable to access the meeting will be adjourned and rescheduled. Christina Dyer is the staff assisting us. Please note that all votes that are taken during this meeting shall be done by a roll call vote. Let's start the meeting by taking a roll call attendance. When each member states their presence, please also state whether there is anyone in the room with you during this meeting, which is required under the right to know law. Madam Clerk, would you call the roll for attendance, please?
Thank you, Madam Chair. Representative Alicea Home with dog. Representative Altschiller. Representative Belanger.
Good morning. Sorry, Representative Alicea, it didn't unmute in time. This is Representative Altschiller,
Okay.
and I am home here in my office in Stratham. Thank you.
Representative Belanger.
I am present in the LOB, and I would like to thank you for pronouncing my name correctly. Thank you, Representative Al.
Thank you. Representative Cross. Representative Cross. Vice Chair Representative Grossman. I'm sorry, DeSimone. I apologize.
No apologies needed. I am here in the LOB room 308 with other legislators.
Representative Grossman.
I am home. I'm here alone. Thank you.
Representative Levesque.
I am here. I am in my spare room alone.
Thank you. Representative Lewicki.
I'm here at the LOB with the other legislators.
Representative Litchfield.
Yes, I am here. I am in my vehicle and I do have 2 children with me.
Are you safe and pulled over?
I am safe and pulled over, yes. Sorry, we just finished a dental appointment, so we're gonna hang out for the hearings.
All right, thank you.
Thank you.
Representative Long.
I'm here at my house alone.
Thank you. Representative Petrigno.
I'm here in my home office alone.
Madam Chair, Representative Rice.
Morning. I am in the LOB with my colleagues.
Thank you. Representative Smith.
I'm here home with my husband and 2 of my 3 kids.
Representative Wazier,
Morning. I am home with my baby.
Representative Yokela,
Morning. I am home with my girlfriend.
thank you, Madam Chair. So everyone is present except for Representative Cross. Is that?
Yes. Okay, great. Thank you very much. And thank you for toughing this out with us. I know you're not feeling well.
Thank you.
Okay, so I'm going to open the public hearing on SB 16. And I will call on, hold on 1 second. Grant Bossy.
He's not,
He's on there. He just raised his hand.
there he is, there he is. Able to open him.
What's the matter?
I can't open him.
You can't open him?
Nope, I'm trying.
Christina, we're having a hard time pulling Mr. Bossy in. There we go.
There he is.
Thank you. Mr. Bossy, can you, there you are. Good morning.
Good morning. Madam Chair, members of the committee, thank you very much for having me. My name is Grant Bossy. I am the Majority Policy Director for the New Hampshire Senate, and I am here today on behalf of Senator Sharon Carson, who is the prime sponsor of Senate Bill 16. As the prime sponsor of many bills, she is actually introducing another one of her primes in another committee at this very moment and has asked me to pinch hit. I appreciate your courtesy. This bill revises the formula for the term alimony to bring New Hampshire in line with recent changes in the federal income tax code. Specifically, the bill recognizes that alimony is no longer either deductible by the payer or taxable to the payee. Some of you may be familiar with this bill as it was debated last year as Senate Bill 444. That bill was rolled into one of the omnibus bills that was vetoed. So we're back at it. I would defer on any of the tax questions to the tax experts that are on and ask for the committee's careful consideration for Senate Bill 16. Thank you very much.
Great, thank you very much. Next, we will have Marilyn Mahoney, who has asked for 5 minutes to speak in support of the bill.
Hello, my name is Marilyn Mahoney. Can you hear me?
Yes.
Okay, great. I am speaking on behalf of a group of attorneys who we called ourselves the Alimony Working Group. We had met and developed the original alimony formula for the law that is currently in effect. And that bill coincidentally went into effect at the same time that the tax law changed the taxable nature of alimony, which threw our formula that we had so carefully developed into chaos. Well, not chaos, but disarray, because suddenly payors who were expecting to have a deduction for their payment of alimony weren't going to get that deduction. And it was completely unfair for those percentages to continue as they were. So the Alimony Working Group reconvened and we ran a number of different scenarios to try to determine what percentage would result in similar outcomes for both the recipient and the payor of alimony, so that the tax consequences would not have a negative or unfairly positive effect on either party. After a number of meetings and running a number of different scenarios, we came to the determination that The 23% of the difference in gross incomes produced similar results to the 30% that was in the original law. So that is the primary thing that this bill is designed to do. It also provides a window for people with alimony orders that were effective on or after January 2019, that is under the 30%, to modify their any alimony orders that were made using that percentage on the basis of the change in the tax law. That window would be open for any orders amounting to more than 23% of the difference. And we didn't want that to be an open-ended window for anyone to come in and modify. So you will see in the bill that the request for modification must be made by July 1st, 2022, which we felt was a fair enough period of time to allow any requested modifications on the basis of that percentage change to be made. The 30% alimony formula took effect on January 1st, 2019, as I said. Prior to that date, divorcing parties could, under the law, choose to use the formula, and many did, and either by court order or in settlement negotiations. So if the divorce was effective in 2018, the 30% formula works as the new tax law continues alimony deductibility for those cases. Another provision adds the impact of federal tax law on the parties. That's a quote, impact of federal tax law on the parties. That gets added to the list of special circumstances that judges may use to make adjustments to the formula. So if there were some unfairness resulting from the taxability, the courts would have the authorization to make such modifications. And it also clarifies that any modifications of alimony orders may be retroactive to the date the other party received notice of the modification petition. This just is a technical issue that clarifies and makes this law consistent with other similar support laws, that a modification can be made, but only back to the date that the modification was requested and the other party was notified of that. This bill also makes very clear that the original alimony statute for the 2001 that went into effect on January 1st, 2019 applies only to divorces filed in 2019 and not to prior cases or modifications that were filed before January 1st, 2019. And it adds a provision on retroactivity on any alimony modification that mirrors the child support law about modification. So that kind of outlines generally what each of the provisions in this bill provides. And I'd be happy to take any questions if anyone has any, but thank you for letting me come to explain the law and to encourage your support of it.
Great. So thank you very much. So this would basically bring our current alimony statute in compliance with federal tax laws, correct?
Correct. That is exactly it. Yes.
Great. Representative Long.
Thank you, Madam Chair. So, Ms. Mahoney, would this apply for any? Would this scenario still apply for any further tax law change that would have the payer paying more because of the tax liability? Do you understand the question?
Not really. I'm sorry.
Yeah, so I'm wondering if the tax law changes again, would we have to modify this statute? Or does this sort of carry over to whatever the tax law changes are?
Well, it would depend on what the change would be, but the inclusion of the language that I mentioned, that the court can take into consideration any tax implications, I think provides some flexibility given the passage of time. So if there were some dramatic change, let's say a return to the deductibility of alimony to the payor, we'd have to return to change that percentage again, precisely for the same reason as why we're here now. However, in the meantime, because of the amount of time it takes to amend a bill or to amend a statute, the court would have the ability to take that into consideration.
Thank you.
Are there any further questions for Ms. Mahoney?
I see no further hands, Madam Chair.
Okay, seeing none, thank you very much for your testimony.
Thank you for allowing me to testify.
Okay, those are the only two people that signed up in testimony. Did anybody want to testify in the audience that has not had the opportunity? I do not see any hands going up.
I see none.
So I will be closing the public hearing on SB 16, and there were 4 signed in support and 1 signed in opposition. And we will be back at 10:30. Thank you.
We saw the email from Moira O'Neill saying she wants to testify.
On this bill?
On 93.
Oh, I mean, if she's on the thing, I'll check. Hold on 1 second.
Who, what's the name?
So it's Moira O'Neill, the child advocate.
Moira?
Can you just want to do this so that you could possibly do this for me?
She just sent us an email saying that she doesn't want to testify, and she thinks that the opportunity is closed.
Tell her,
Hey, Madam Chair. Representative DeSimone?
Representative.
Oh, do you know if we're going to be execting any bills today?
Well, I was gonna text you in just a minute because it seems to me we could probably accept the one we just did.
Okay, great. Yep. Thank you.
Okay. Hi, everybody. Is everybody still there? Representative Alessia, could you get the paperwork ready to exec SB 716? Because I think we can get this one done right away. I'll give you a few minutes. We don't have to do it right at the moment. I need everybody to come back anyways, but.
SB 16.
Yeah, the one we just did.
Yes.
Yeah, we're gonna go ahead and exec that once we have everybody back. Deb, would you like to make the motion?
Certainly.
Well, we're gonna wait. I gotta wait for everybody to come back.
When they're ready. OTP.
Yep. So if we don't have any problems with those two, we can accept those right now too.
Yep.
So,
This is it for our bills so far.
so far, that's it. Which is good because I've got 30 million with the stills and judiciary.
Right.
Okay. Are they on board with those two?
But yeah,
Good.
I mean, they have a few questions, as I'm sure we all will, but you know,
Yeah.
I just have to wait for everybody to come back because I sent them all away until 10:30. So we may have to wait until the end, but.
Do we want to do another roll call before?
No.
Just
Nope.
make sure they're
Just
here.
gotta- Cameras have to be on anyways to
Yes.
exec, so. That's why I'm waiting, because I did tell everyone I'd see them back here at 10:30, so. Yeah, at least Carolina can get ready.
Right. One, two, three, four, five. 5 more. One. These.
I put that address in Cody and it gave me nothing.
Yeah,
It
so,
didn't even get me to an access road. Yeah, it's like it didn't exist. There was nothing like that in Newbury, Vermont.
I hadn't even checked yet,
So
so
you
that's
know.
good to know. I'll let them know and ask for a better location.
I was trying to fill out the mileage thing, you know, so
Oh.
that I would know how much mileage it's gonna be.
Can you send me that?
What?
The mileage?
I don't have it.
Oh,
Fortunately, I have a staff person that helps me out with this stuff, but I can get it.
thank you. Yeah,
Madam Chair,
Yes, Yes, Madam Clerk.
may I assume that the two people that spoke did have a written testimony?
Mr. Bossy didn't, but he was basically just introducing the bill. Marilyn Mahoney, I believe, did. I'm sorry, I forgot to ask. Oh,
It's okay. She generally does, but I didn't want to interrupt her.
here.
I took notes as well, but just,
Okay, I'll look for the SB 16. I don't see any from Marilyn Mahoney, but I'll look.
didn't get an email from her.
Yeah, I don't think that we had written testimony from her.
Representative,
fine.
I didn't have written testimony, but what I had was drawn from the Senate Judiciary Committee report on the bill. And I could have
Yes.
Jenny Horgan send that to you if you'd like.
That would be great.
Would you please?
Senator, yeah.
For the rest of the members of the committee, if you are back and you are listening, can you please turn your cameras on so that we can continue to exec Senate Bill 16. As soon as you turn your cameras back on, we can move on. Thank you.
I just don't think they're there because I told them.
I don't think so either. There's Deb. Yeah, 3 more. No, 2 more.
We're gonna have to go to the public hearing and we'll just accept the end.
So I just tried putting the address in on Google Maps and it literally says address not available.
I know.
I was like, wait,
I'm not
what?
joking, right? So like, I was
He sent me
completely factual.
He sent me an email about it. I tapped on the email address and
It brings me to Stephen's
Robbie.
place.
right up.
It brings me to a different address.
Yeah.
On my phone. All right. I will get this sorted out, I promise.
3 minutes.
Okay, well. It is what it is. And here is Grant Bossy over here. Here.
Yeah, I just stayed as a panelist, so I think I'm all set for when you need me.
Seven. Oh, there he is. Okay. Two minutes.
Yeah.
Madam Chair, it's 10:30.
Okay, I have 10:29, so I was just trying to.
Oh, okay. AT&T.
My phone says 10:29 also, so.
$10:30.
Okay, good morning, everyone. We are back. So I am now going to open the public hearing on SB 93. And I will call on Grant Bossy.
Thank you, Madam Chair and members of the committee. I am Grant Bossy, Majority Policy Director for the New Hampshire Senate, here again on behalf of Senator Sharon Carson, the prime sponsor of Senate Bill 93, who is off introducing other bills in other committees at this time. And she again thanks you for your indulgence. This bill grew out of a legislative study committee that was convened in 2019. It's also the recommendation of the New Hampshire Model Court Project, and it would bring some clarity to the permanence process under the Child Protection Act. Specifically, the bill clarifies that adoption, rather than the termination of parental rights, is a potential permanency plan objective. clarifies the timing of the 12-month permanency hearing, and specifies other circumstances for which a subsequent permanency hearing may be conducted. In some cases, it allows for an earlier permanency hearing if the parents are in compliance and the unique needs of the child present circumstances that justify it. And it also gives the court the ability to modify a permanency plan by agreement at a post-permanency hearing. This would bring clarity and permanence to the adoption process, benefiting children and their adoptive families, and we ask the committee for its consideration. Thank you very much.
Great, thank you very much, Mr. Bossy. Next up, Judge Ashley was supposed to testify. Unfortunately, she is unavailable today, but she does have written testimony that was emailed to all of us, so I would encourage you all to please look at that. And we also have Richard Head here, just in case any questions come up for the judiciary. Representative Altschuler.
Yes, we have an email. I'm not sure if she's in the waiting room, but the Office of the Child Advocate, Maura O'Neill, emailed us saying that she had tried to register to speak, but the registration was closed. So if she's in the waiting room, she would like to present her testimony.
Thank you, I know that. Thank you.
Okay, great, thank you.
Madam Chair, she is not yet in the waiting room.
I know, I have other people to call on, you guys. Really, I have this under control.
No, I just wanted to let you know.
Representative Belanger, do you have a question?
I do, Madam Chair. Thank you.
For whom?
It would be for, where did he go?
Mr. Head? No, Grant Bossy is not taking questions.
Okay.
He's just presenting it for
Okay.
Senator Carson. When we get to questions that we need for the court, then I will ask Mr. Head if someone else cannot answer it for us,
Perfect.
okay?
Thank you.
Okay, so up next, we have Rebecca Ross to testify in support, and she is with DCYF. So can you pull Rebecca Ross for us?
Yes, I can. There you are.
There you go.
Members of the committee, Madam Chair, thank you for the opportunity to provide testimony this morning in support of Senate Bill 93. As introduced, this arose out of recommendations from a study committee and was a collaborative effort with the model court and representatives of all disciplines that are engaged in child protection hearings. Judge Ashley's written testimony does a phenomenal job of summarizing the different parts of the bill, and I'm not going to walk through each of the parts, although I'm happy to take questions on any of them if members have them. We are in support of this bill because we believe it better meets the needs of children and family who are involved in the child protection system. It provides clarity in the process, both at the beginning phase and at the end of the permanency process, and explains what to do when the unique needs of the child and family don't fit within the cookie cutter 12-month permanency hearing process. The bill is about meeting their needs early. If efforts are not being made, that the child can move on through permanency and ultimately adoption, if that is what is appropriate, and gives the court direction on how that will work and when those hearings will occur and what the burden is for those hearings. That was one of the driving factors in the study committee last year, looking at whether or not the 12-month permanency hearing was appropriate. So we addressed the committee's needs with providing for a limited exception for early permanency hearings, as well as providing detail on the process for the other end when we get to the 12-month mark, and whether it's that the folks are almost there and reunification looks like a reasonable outcome, or whether it's because of the unique needs of the child that permanent or reunification has not been achieved yet. The court will now have direction on providing one limited extension for a permanency hearing in order to allow the court and DCYF to meet the best interest of the child. This is particularly good timing to make these changes and revamp this permanency process because it corresponds with all of the other changes that the legislature has supported to the service delivery system, including more preventative services through community-based voluntary services, as well as the system of care changes for children's behavioral health, which will be able to step in for those cases where it's the unique needs of the child, preventing reunification at the far end of that 12-month process. So we believe that all of the changes in this bill are appropriate, will provide clarity and consistency through our courts and to our families, and is consistent with the service delivery changes that are being made and will be very helpful in supporting families accessing those services and meeting the best interest of children. And I'm happy to take questions at any time.
Great, thank you very much. Representative Belanger.
Thank you, Madam Chair, and thank you, Ms. Ross, for your testimony this morning. Thanks. Trying to get ahead of myself here. In the case where, does this, in your opinion, does this bill reflectively respond only to cases in which DCYF is involved?
Yes, this is under the Child Protection Act and would be in an abuse and neglect case that the division is a party to.
Okay, thank you.
Right, are there any further questions for Ms. Ross? Okay, seeing none, thank you very much. Okay, up next will be Marcia Sink to speak in support of the bill, and she is with CASA of New Hampshire. Ms. Sink, can you unmute?
I'm sorry. Sorry about that.
Good morning.
Good morning. Thank you, Madam Chair, and thank you, members of the committee. My name is Marcia Sink, and I am the CEO of CASA of New Hampshire. And I've been with CASA since its inception in 1989. CASA is statutorily mandated to serve as guardian ad litem on cases of child abuse and neglect. In fiscal year 2020, 630 CASA volunteer guardians ad litem advocated for 1,455 of our state's abused and neglected children. CASA fully supports Senate Bill 93. Judge Ashley's written testimony explains quite well the proposed changes to the statute, which will better support children and families as it continues to encourage timely permanency for children and youth whose best interest is paramount. CASA supports the bill in its entirety, but I'd like to focus on the impact of extensions and delays and how this bill addresses the necessity to allow at times and with limits those extensions. And all too often we see significant delays in permanency for children and the damage and additional trauma our system can inflict on these already traumatized children and youth as they wait for closure. Even when children and youth are in their pre-adoptive homes, we have seen disrupted placements as these victims wait for months or years for the court and the parties to come to final decisions about their lives, waiting to be adopted or waiting to go home. Last June, I had the opportunity to virtually attend a Nashua area celebration of reunification. It was attended by DCYF workers, supervisors, CASA volunteers, and others. But most importantly, it was attended by families that had been successfully reunified. I'll never forget, and this has just stuck with me, one mom on this Zoom call with her 2 children sort of hanging over her shoulders who were laughing and smiling so they could get their faces into the screen to be seen. And this mom called out Judge Leary, who took the time to be with them that evening. And she said to Judge Leary, if you had not given me more time, I would not be sitting here right now with my children home with me. And this was an example of how one mom working hard in recovery was given the additional time and enabled the opportunity for her children to come home. We believe that it's in the best interest of our CASA kids, as we call them, to be entitled to the reassurance that this bill will provide for timely permanency. One little 9-year-old boy whose case had been open for several years said to his CASA Bob, "You better hurry up and get me adopted because I'm not going to be cute much longer." When reunification is not the plan, then seemingly endless days to children waiting can cause irreparable and permanent harm. Timely permanency is critical to the well-being of children and their families, and Senate Bill 93 will provide clarification in the statute and specific guidance to the courts and all parties regarding just how long we can allow children to linger in a place of uncertainty. Thank you. I'm happy to take any questions.
Thank you very much for that testimony. Are there any questions for Ms. Sink? Okay, seeing none, thank you very much.
Thank you.
Up next is Suzelle Jerez. I hope I didn't butcher that name too badly. To speak on behalf of herself, and she is neutral and has asked for 3 minutes.
Good morning, Madam Chair and members of the committee. I'm so sorry, Madam Chair. I thought I had registered in support. I must have clicked the wrong selection. I'm so sorry about that. Good morning, members of the committee. My name is Suzelle Jerez, and I am speaking to you today in support of Senate Bill 93. Just a little bit about myself. I am a Master of Social Work student at the University of New Hampshire. And I also work for the Mental Health Center of Greater Manchester. However, today I am speaking as a citizen. Actually, in the interest of time, Ms. Sink touched upon a lot of my points that I was going to bring to you today. So just to reiterate some very important points that she made, Senate Bill 93 does an incredible job at clarifying compelling reasons as to why early permanency or extensions can be important in permanency hearings. A study conducted in 2018 found that over 37,000 youths are emancipated from the foster care system without any kind of permanency plan. This study also talked about the impacts that this has on the mental health of children and youth in our system as they wait, an endless amount of time, whether that's months or a year or even the 12 months even. That's 12 months that children are in our system wondering what their future looks like. And a lot of these children feel hopeless at times, especially as they begin to age, because unfortunately there is this thought and a stigma around the fact that older youth are unadoptable. In these cases, I think early permanency hearings can make a great difference in the mental health of our children and youth in the state of New Hampshire, and I urge you to take that into consideration. No one wants to be taken out of an abuse or neglect situation just to feel neglected by the system that's there to support them. So I thank you for your time today. I don't want to take up too much of your time. As I said, Ms. Singh did touch upon a lot of the points I was going to make. I strongly urge you to vote in support of Senate Bill 93. Thank you. I welcome questions.
Great, thank you very much. Are there any questions? Seeing none, thank you very much for your testimony. Up next will be Moira O'Neill, the New Hampshire Child Advocate, the Director of the Office of the New Hampshire Child Advocate. Ms. O'Neill.
Good morning. Thank you, Madam Chair and members of the committee. I'm sorry to make a bit of a fuss to have you hear me today. I appreciate you taking the time. I'm, for the record, Moira O'Neill. I am New Hampshire's child advocate, and I'm happy to speak in support of Senate Bill 93 relative to permanency planning under the Child Protection Act. We do absolutely support the bill. I don't think I can add to the eloquence of Marty Singh from CASA New Hampshire and what this means in terms of the concept of permanency. I will point out that one of my staff noticed last summer in the midst of all the angst around COVID-19, that our experience of the pandemic and the lockdown was very much like the experience of a child awaiting permanency. We now know all about the impact of being separated from loved ones and not knowing what's going to happen next. And so I hope that we use that shared experience to inform decisions going forward. As I said, we do support the bill and its intent for smooth transitions when natural parents are unable or unwilling to be parents. We do, however, want to take advantage of your time, if you'll be so generous, to just make one comment on something that we have a concern and we want to share. Should this bill pass and become part of the legal fabric of families' lives, we want to urge the Division for Children, Youth, and Families, the courts, CASA GAL, providers, foster families, and all those that are involved in the lives of children who are removed from their parents to be mindful of the extent of loss involved when parents' rights are terminated. Permanency shouldn't be exclusive of important relationships. In the Office of the Child Advocate, we've observed children who had meaningful relationships with parents who were just unable to parent. The Office of the Child Advocate recently released a system learning review summary on 4 children's cases, including the case of Joseph. Joseph lost a deep relationship with his mother, who visited him regularly and whom he never saw again after her rights were terminated. He later lost a relationship with a foster mother and then his aunt and uncle. While we don't disagree that those 4 people may not have been able to meet his needs as permanent caregivers, they did and still do mean something to him. He's left with trying to understand whether they failed him or he failed them. So these relationships, in whatever form they might end up being, are integral to a child's self-worth and ability to bond with others. One of the most common calls that we receive at the Office of the Child Advocate is from a grandparent, aunt, or uncle who just want to be a part of a child's life. Often they have strong bonded relationships with the child. Some are fighting to be parents when actually they would be best suited to remain the child's grandparent or aunt or uncle. Unfortunately, those opportunities are rare. So we understand that you cannot legislate or force relationships amongst families and foster or adoptive families. However, we would be remiss if we didn't take this request and put it on record. That as we take a close look at the law to be sure children are able to rest in permanency, that the people who influence children's relationships do whatever they can to promote and support the salvaging of relative relationships in whatever form, in the best interest of children. So the Office of the Child Advocate urges the committee to pass Senate Bill 93, and we also ask consideration from those involved to be sure of the importance of family relationships for children in all decisions rendered on their behalf. So thank you very much for giving me that time to say that. I'm happy to take questions if you have them.
Thank you very much, Ms. O'Neill. I have to agree with your points. Thank you for bringing those up. Any questions for Ms. O'Neill? Representative Lewicki.
Thank you, Madam Chair. Thank you, Ms. O'Neill. One of the things, I'm not really familiar with the process, and if you could give a brief overview of how the schedule works and so forth, it might be very helpful to me and possibly other members of the committee.
Thank you so much for that question. I really regret that Judge Ashley wasn't available today, and I would refer you to her testimony as she understands the details of it and can explain it so much better. In general, when a child comes into care, there's an expectation for permanency within 12 months. And so what this law does is give some flexibility, sometimes for that 12 months to be shorter and sometimes for that to be longer. The 12 months is based on sort of the idea around the developmental needs of a child, the bonding relationships necessary for children, and the idea that permanency is so important. Unfortunately, it doesn't always align with treatment schedules. So the availability of someone to be ready for, say, for example, substance use treatment, to be willing and able and to access services sometimes don't align with that and may take longer. There are also times when it's very clear that a child's not going to be able to be reunited with parents because of incarceration or severe illness or other factors. And in that case, that child may be waiting for a long period of time for that decision to make because of the expectation around the 12 months. So this just gives a little bit of flexibility in the courts so that all of those persons who are working in the best interest of the child will be able to make that child feel as though they're at home and they have some permanency.
Thank you.
Great, thank you very much. Are there any further questions for Ms. O'Neill? Okay, seeing none. Thank you very much.
Thank you so much.
Okay, so I'm going to close the hearing on SB 93. We're going to take a quick 5-minute break so that the clerk can get ready so that we can exec, because we have time before the next hearing. So let's exec SB 16 and SB 93, but I need 5 minutes. Everyone hear me? I apologize. I didn't have my mic on. We're good? Okay. So just give me 5 minutes, please.
First.
Thank you. Okay, everyone, I'm going to call everyone back. I'll give everyone a few minutes to come back to turn their cameras on so that we can exec SB 16 and SB 93. And as a reminder, in order to vote, your camera has to be on. Text Josh.
Yeah. That's right.
So I'll give you a couple of minutes. And Madam Clerk, are you good to go?
Yes, Madam Chair.
Okay, give Representative Altshuler a minute.
Excuse me, Madam Chair.
Yes.
I just wanted to let you know that I am in my home at this point in time, and I am in the room alone.
Great, thank you very much. Okay, so I'm going to open the executive session on SB 16, amending the alimony statute, which in my, is basically a formality. Does anyone have any further discussion on it? Looking for hands raised. Okay, well, I don't see any, so Madam Clerk, can you call, oh, never mind. Representative DeCone, do you have a motion?
Madam Chair, I'd like to make a motion of OTP on Senate Bill 16.
Second.
Representative Belanger seconds that. Is there any further discussion? Representative Long, oh, there we go, okay. All right, I don't see any further discussion, so I will ask the clerk to call the roll.
Vice Chair Representative DeSimone.
Yes.
Madam Chair.
Yes.
Representative Rice.
Yes.
Representative Yokella.
Yes.
Representative Nowicki.
Yes.
Representative Belanger.
Yes.
Has Representative Cross come in?
No.
Representative Litchfield.
Yes.
Representative Smith.
Yes.
Representative Long.
Yes.
Representative Ali Sayed, yes. Representative Grossman.
Yes.
Representative LeVay.
Yes.
Representative Oisier.
Yes.
Representative Petrigno.
Yes.
Representative Altshuler.
Yes.
Madam Chair, the vote is 14 yeas, no nays.
Okay, without objection, SB 16 will be placed on the consent calendar. Okay, and I will give Madam Clerk a minute to get ready for SB 93. So just give her a minute to.
Yeah.
Just let me know when you're ready.
I'm good.
Okay, I'm going to open the executive session on SB 93 and recognize Representative DeSimone.
Thank you, Madam Chair. Madam Chair, I move ought to pass on Senate Bill 93 FM.
Thank you. Seconded by Representative Belanger. Is there further discussion on SB 93? Nope. I would just like to say I really like this bill, and it's not because I'm a co-sponsor. So, all right, seeing no further discussions, I'll have the clerk call the roll.
Vice Chair Representative DeSimone. Vice Chair Representative DeSimone.
Yes.
Madam Chair Representative Rice.
Yes.
Representative Yokela. Sorry.
Yes.
Representative Lewicki.
Yes.
Sounds like,
Representative Belanger.
yes,
I'm sorry.
yes.
Thank you. Representative Cross is not here. Representative Litchfield.
Yes.
Representative Smith.
Yes.
Representative Long.
Yes.
Representative Ali Sayed, yes. Representative Grossman.
Yes.
Representative Levesque.
Yes.
Representative Wazir.
Yes.
Representative Petrigno.
Yes.
Representative Altshaw.
Yes.
Madam Chair, the vote is 14 yeas, 0 nays.
Great, thank you. But that cannot go on consent due to the fiscal note. Okay, so we have about 12 minutes before our next public hearing. So we'll see you back here promptly at 11:15. Thank you.
That's okay. I can,
Okay. All right. Okay, everyone, we have 1 minute, so if people could stop meandering back to their computers, that'd be great.
I have a different picture of my Zoom than. Really?
I do not see, is Grant still on here, Grant Bossy?
I do not see him.
Okay, oh wait, there's Senator Carson. Okay, so we're good. All right. Okay, friends, it is 11:15. So I'm going to open the public hearing on SB 94 relative to juvenile diversion programs. And I will call on Senator Sharon Carson.
Here we go. Good morning, Madam Chair, and good morning, House Children and Family Law Committee. For the record, my name is Sharon Carson, and I have the pleasure of representing Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I have this morning for your consideration Senate Bill 94, which seeks to clarify the procedure for obtaining a needs assessment through juvenile diversion prior to proceeding with a delinquency petition under RSA 169B. This bill was filed at the request of the Juvenile Justice Transformation Group. This was a team that was formed in November of 2019 through a federal grant, and the team went to Georgetown University to learn about the latest in juvenile justice. The team included Director Ribson, 2 other members of the juvenile justice staff at DCYF, New Hampshire Child Advocate, a judge, and the chair of the Juvenile Diversion Program, the Public Defender's Office, and a prosecutor. This bill is one step of the plan that has been formed out of the work of this team. The bill requires law enforcement and prosecutors to refer youth for a needs assessment prior to filing a delinquency petition, except in cases that involve the most serious offense. The proposed assessment is voluntary and it is meant to allow the department to identify the needs of youth prior to court involvement. The goal of this legislation is to lower court involvement with the use of appropriate community service. And this is also to be seen as an extension of our current system of care. And so really what we want to do is try to get these kids that are in difficult situations services prior to involving the court. So with that, Madam Chair, I will end my testimony. And unfortunately, I have to get back to House ED&A on an omnibus bill. So I'm going to ask to defer the questions. I'm sure that there are a lot of people who would like to speak on this bill. So I appreciate your time this morning and wish everyone well.
Thank you, Senator. By any chance, did you have written testimony to submit?
No, I did not.
Okay, great. Thank you very much. Have a great day.
You too. Thank you.
Okay, up next is Michael Skibby to speak in support of the bill, and he's asked for 5 minutes. Could you please state your name, where you're from, and whether or not you have written testimony?
Good morning, Madam Chair. Michael Skibby from the Disability Rights Center. I do not have written testimony, and I'll just testify briefly. This is a bill that I think, well, let me just stop for a moment and thank Senator Carson for her sponsorship of this bill. I think thanks also go to Mr. Ribson and his staff and the other members of his working group for reaching out to me and to other members of the Juvenile Reform Project, such as Waypoint and the ACLU and New Hampshire Legal Assistance, a group that I think you're all familiar with on our juvenile reform efforts. They engaged with us in, I think, a very constructive and productive way. And I think that the result was a bill that is deserving of your support. It's certainly something that I support. I think that one of the challenges of juvenile justice is sort of a paradox that as the system responds to misconduct on the part of youth, it oftentimes makes things worse, not better, through no bad intention. But the fact of the matter is that the more deeply a child gets pulled into the juvenile delinquency system, the more often the recidivism rate goes up, not down. And oftentimes that is most apparent when you're talking about very minor offenses. The more formal and firm, if you will, the response on the part of law enforcement, on the part of courts, on the part of the other elements of the system, the more likely it is that the child will return again and again. Oftentimes that's because of self-labeling. Oftentimes it's because of stigma in their community. Oftentimes it's because of the weakening of protective connections that are extremely important for children who are at risk of future delinquency. And so it's very important, if possible, and if it can be done safely, to have as therapeutic a response as possible, and to have that response be outside the court and the other elements of the formal justice system. And I think Senate Bill 94 does that, and it effectively balances the needs of the formal system with the treatment needs of the system and what it's really trying to accomplish in terms of therapeutic responses. I won't go into detail into sort of describing the bill. I'm sure that Mr. Ribson or one of his colleagues will do that for you. But I think that one of the concerns that we had was to make sure that if early in a child's encounter with law enforcement and with the juvenile justice system, they're being asked questions about their treatment needs, there are certain risks that come with that can be important for the fairness of the adjudicatory system. That is, is a child going to be asked questions that could later be used to against them in court? And that's a very difficult and challenging issue to deal with in a way that both gets the information to frame services in an accurate and effective way, but also protects the child's rights if in fact the formal system proceeds. And I think that this bill does that very effectively. And again, I want to thank Mr. Ribson and his colleagues for being willing to engage on that issue and other issues that were of concern to us. I'd be happy to answer any questions. Thank you.
Great, thank you very much. Representative Long.
Thank you, Madam Chair. Mr. Skibby, do you have the bill in front of you by any chance?
I do.
I'm not sure if you'd be the one to answer it or maybe Mr. Ribson, but when you look on page 2, line 15.
Yes.
The department shall obtain the consent of the minor and the minor's parent and guardian. Then when you look at B, and there's two other places in this bill where it says if the minor or the minor's parent does not consent. Do you see a possible misunderstanding where it first starts off saying both need to consent and then it leaves it up to one or the other?
Do I see that as a practical problem? Is that the question?
Yes.
Well, I can certainly imagine circumstances where that could be challenging. And I suppose, I think we would all have to live with the one possibility, which is that the minor wants to go one way and the parents want to go the other, and the parent have to remain in the driver's seat. With regard, let's say that the minor objects and the parents want to proceed, or let me put it the other way: the minor doesn't want to proceed, but the parents want to proceed. I think that that's pretty problematic. Well, let me start over. I think that one of the problems that we have is that for this process to work, you have to live with the sort of tradition and the legal framework that we have, that minors are really subject to the wishes of their parents or guardian. And so you can't subject a minor to involuntary medical treatment without the consent of the parent or guardian, or an assessment without the consent of the parent or guardian. I just don't think there's any way around that unless you're part of some sort of legal proceeding. So I think that's really the problem. But it would be unfortunate if the parents are wanting, well, I can imagine circumstances where there would be a lot of frustration about, the parents wanting to proceed, the system wanting to proceed, and because of the minor's objections, it's not going to go forward.
Okay, thank you.
Are there any further questions for Mr. Skibby? Okay, seeing none, thank you very much.
Thank you.
I'm going to go a little out of order right now so that we can hear from Joe Ripsum, the director of DCYF, because I think he or Ms. Ross may be able to answer questions for us. So Director Ripsum.
Great, thank you, Madam Chair. Can everybody hear me?
Yes.
Wonderful. Joe Ripsum, for the record, Joe Ripsum, Director of DCYF. I am in my office in Concord alone. Just a bit of warning, they're doing work on our fire alarm system today, so hopefully that won't happen in the middle of my testimony, but it could. And thank you, Senator Carson, and thank you, Representative Belanger, for bringing this forward for us. This is really important work. I'm very, very grateful to the host of stakeholders who have been involved in this process, and very, very grateful to the host of stakeholders who are going to continue to be involved in this process, as this is just one part of a very ambitious project to really kind of redefine the way that juvenile justice works in this state. And we're trying to do it by including all the voices that have a stake in this, parents and family voice, youth voice, all of the professional stakeholders. And that's not always easy. Sometimes folks have disagreements about some of these things, and we try to wrestle with them, but we're trying to take all concerns seriously and move forward in a way that makes sense for everybody. So as Representative Carson, or as Senator Carson shared, this bill was crafted by what we're calling the Juvenile Justice Transformation Group, which was a group of folks who in November of 2019 were awarded a grant to join a project down at Georgetown University with the support of the Annie E. Casey Foundation, for the purpose of really thinking about juvenile probation and what works and what doesn't work, and for the purpose of really trying to make sure that kids who end up in that system are the kids who need that system, and that there are lots of kids who don't need that depth of intervention, who could be served in a more voluntary fashion without having to get deeply into that system. It's smart for kids. I think it makes kids have better outcomes, but it's also smart from a resource perspective, where you currently have a lot of kids going through the formal system who probably didn't need to be there, and that takes up attorney time. It takes up precious bench time, which is a commodity that's hard to find across our state, and it takes up time of juvenile probation staff. And what this bill seeks to do is to kind of shift part of the role of our juvenile probation staff to make them more proactive and preventative in their work, instead of having to only be reactive to court cases. So now let me go into a little bit about what this bill actually, how this is supposed to work. So what this does is it really quite simply creates a process by which whenever a child has contact with law enforcement, be it an arrest or not, we don't want to force people to arrest kids, but if they have contact with law enforcement may refer to the department to have a strength and needs assessment conducted. The family and the youth do have to consent to having that conducted. This is not supposed to be a compulsory thing. It's a way to try to voluntarily get kids out of the system. We will then conduct that assessment, and we'll make a recommendation as to whether there's community-based services that could help, things like Fast Forward, perhaps, if there's a behavioral health intervention that needs to be provided, or even a voluntary case with juvenile justice. There's what we call voluntary chins, which don't have to go through the formal court process, but allows families and youth to access all the services that DCYF can pay for and provide if they're clinically appropriate. So the idea is to conduct that voluntary assessment, and then at the end of that voluntary assessment, we'll provide a recommendation back to the referring entity, typically a law enforcement prosecution, about what types of services we've recommended and whether we recommend that a formal case needs to continue to be filed and move forward. It's really important to note that it's a recommendation. It's not mandatory. Nobody, no prosecutor is required to follow our recommendation, but they will have our recommendation. And I do think that's an important part to ensure that they have some independence in their decision making as well. So we're conducting an evaluation. We're making a recommendation. We think for many youth, they're going to voluntarily engage and be able to be diverted from the formal system. But if they choose not to, and if a prosecutor decides that for the purposes of community safety or whatever, that they want to proceed, they'll be able to do that. The other big piece of this is, in addition to that assessment being able to be used at that front end to be able to determine whether there are services that can be provided before kids go to court, it also is useful if kids actually do go to court. So what happens today in many, many cases is that kids end up going through court and that dispositions are then filed without anybody ever actually assessing what the kids' needs were. And you end up in a situation where largely attorneys are making what are clinical decisions, whether that be judges or defense counsel or prosecutors making clinical decisions about what kids really need without ever going through an assessment. And that doesn't make a whole lot of sense to me. You really need the advice of the people who understand kids' needs to be able to make those plans. So the other big piece of this is that when that assessment occurs, even if a kid ends up going through the court process, that information could be used to develop better recommendations for youth who do need to go through the formal system to make sure that the things that we're providing actually make sense for what the kids need. Again, I just want to, speak a little bit to Representative Long's question around the voluntary nature of the assessment process. It's voluntary. It requires both the parent and the youth to consent, largely for the reasons that Mr. Skibby put forward. I don't think the two sections are irreconcilable because it requires in A, that both parties consent for us to conduct the assessment, and in B, it switches to the negative. So if either party objects, we cannot then share that assessment information further. So I do think that they can be read together to work as currently written. Because we're requiring in the first instance both to consent to start, and in the second instance both to consent to proceed with sharing that information. As Mr. Skibby pointed out, there were some additional protections put in place, and it was never our intent to use this as a way to get information from youth to be able to have that be used against them in an adjudicatory process. It's really about identifying needs. So with the help of Mr. Skibby and some of the other stakeholders, we were able to craft some language to make sure that you don't have to worry about anything that a youth discloses during that assessment process being used against them in a delinquency process through the courts. So that information is only allowed to be used, again, with the consent of the youth and the family. And again, this is all really about identifying needs sooner, getting kids what they need sooner, keeping them from getting deeper into the system. And with that, I'm happy to take any questions that folks have.
Great, thank you. So I have a quick question. 27 people signed in opposition to this, and a lot of them seem to be from police departments. So I'm curious as to if you would have, because no one signed up to speak against it, but what their issue would be with this.
Yeah, I don't want to speculate too much. I will say, as part of this project, we have been holding a host of meetings. I think Representative Long was at some of them. I think a few other folks were at some of them as well, where we've walked through what the plan is with this work, and then had what we called affinity groups, where all the different stakeholders could come in groups like themselves and share their feedback. And we did have some law enforcement folks show up at the law enforcement affinity group who expressed some concerns, largely around, I think, frustration that a lot of the changes that have taken place in the juvenile justice system over the past decade have taken place without their voice at the table. And there might be more specific concerns than that, but that was a lot of what we heard. And I think a lot of skepticism that this will actually work, because I think in some of their experiences, they've not seen diversion programs be as successful as they'd like them to be. And I think, again, I don't want to set up a straw man. They can certainly speak for themselves as to what their concerns were, but those are the concerns that I heard. And in response to both of those things, I think my response would be, one, we want everybody at the table we've been trying to get everybody at the table. There are a host of sessions coming up about how to implement this work going forward, that certainly anybody and everybody who's concerned can be part of that in order for us to make sure that this works. And secondarily, we're trying something new that's not the same as how these things work today in this state, right? So you can't really compare how the current system works to what we're talking about doing here. Because what we're talking about doing here is totally new and totally different. And then lastly, just to emphasize, as I said in my testimony at the start, nothing that we decide through an assessment process is going to tie their hands in terms of what they decide to do moving forward with the court process. This is about providing alternatives, providing information. And what I think is going to happen is that we'll find that those folks who are skeptical will find that youth are doing better. And at the end of the day, they'll be happy with having another opportunity to have somebody else take a look at a kid and try to solve the problem. But change is hard, and I think that's part of what we're hearing.
Right, because we can't be afraid to try new things, 'cause, then we're just stuck in the same old ruts.
Right.
Okay, Representative Long.
Thank you, Madam Chair. Actually, that was one of my questions with respect to police. It appeared in the bill that they had a little more responsibility, but then when I keep rereading it, it appears that they, am I correct, Joe, that they would, the arresting officer would revert this to the agency, which is the, to Health and Human Services, correct?
Yeah, yep. Their only responsibility is that they can make a referral for any kid they come into contact with. And if they think if they plan to go to court, then they shall make a referral before they go to court. There is an exception for emergency situations, right? If you have something really extreme that happens for which a kid requires immediate placement or detention, they don't need to wait for that process. They can move forward with that and we'll do the assessment later. But that's a very, very slim number of the cases that we get. The vast majority of times, kids get arrested, they get in trouble, and it's a month or so before the case actually goes to court. And the plan with this is that this intervention is going to occur within the first 30 days so that people have the opportunity to have this information when they make their decisions. So yeah, their only responsibility is going to be to make a referral and then to get the feedback from us.
Okay, thank you. Could I get a follow-up, Madam Chair?
Certainly.
Actually, Joe, do you have the bill in front of you by any chance?
Yes.
Actually, on my same question that I had with Mr. Skibby, which I'm becoming a little more comfortable that it's not a conflict, but just to be clear, on page 3, line 16, it refers to the minor or the minor's parents or guardian not consenting to the assessment. Do you see, I just don't want, I don't want to see a parent coming to us down a line saying, my rights were taken away from me because I thought this was in the best interest of my child. My child didn't think so, so you don't see an issue with the beginning. It starts with an and in 2 spots it's an or.
I don't think the ands or the ors are the challenge, because the 2 ors are where it's a negative, right? If either party does not consent, it can't proceed. Where the first one is an affirmative. In order to start the process, both parties must consent. I do think the issue they're raising is something that could happen, right? And that's something that I think is going to need to remain in the bill. The idea that we are requiring youth and parents to consent, and part of that's because what we're doing here, which isn't entirely natural, but it's part of the evolution of juvenile justice, is that we're kind of overlaying a treatment model into what's historically been a correctional model. And in a correctional model, right, youth have attorneys and they have rights, even if parents disagree. And I think that's really what's the discomfort in this space. And maybe someday we move to a place where the systems are more treatment-based and those tensions go away. But as we are in the evolution of a system today, I think we have to structure it in a way that keeps youth rights in place with their counsel. They have attorneys to represent them in these matters, as well as parental rights in place to make these decisions.
May I have one more, Madam Chair?
Sure, one more follow-up.
Thank you. Now, at this point, there's not an attorney assigned, correct? Because there hasn't been any filing with the courts. Am I correct in that?
Yeah, at the point of the initial assessment, there would be no counsel yet assigned.
Okay. Okay, thank you.
Yep, and that's part of the reason why we put this later consent provision in before it can go to court, to address that situation, right? I think an ideal system without regard to cost, you would have an attorney assigned at the point of an assessment, but that would really drive up the cost of a bill. And, you know, I wouldn't be opposed to that, but that's a much bigger issue, I think, for the state. So.
Okay, thank you.
Thank you. Representative Lewicki.
Thank you, Madam Chair. Mr. Ribson already answered my question when he was answering Representative Long.
Oh, okay, great. Thank you. All right, are there any further questions for Mr. Ribson? Okay, seeing none. Thank you very much, Joe.
Great. Thank you, everyone.
Okay, up next is Pamela Jones from the New Hampshire Public Defender's Office to speak in support of the bill. She's asked for 5 minutes. Could you please state your name, where you're from, and whether or not you have written testimony?
Good morning. Can you all hear me?
Yes.
Great. I am Pamela Jones. I am from the New Hampshire Public Defender, the Nashua office. I'm currently in my home office by myself. Thank you for having me. I'm really grateful to be able to be here and speak. I should tell the court, I'm used to talking to the court, I'm sorry. I should tell all of you that I am a member of the Transforming Probation team that Joe was referring to. I have been a public defender for nearly 13 years. My practice has been primarily concentrated in juvenile defense, and I have been a liaison, such as being on the Transforming team, to other stakeholders, to include the Department of Health and Human Services, the Office of the Child Advocate, the courts, the office, the New Hampshire Legal Assistance, and the Disability Rights Center. We all are working towards a common purpose of improving services for juveniles, and New Hampshire Public Defender supports all initiatives with that agenda. We support the passing of SB 94 in particular because the goal of SB 94 is to decrease the number of system-involved youth, to divert formally and informally youth away from the system, to offer services that are individualized and to the youth's specific needs. For those reasons, we support the bill. We support it because it comes from a place of understanding adolescent brain development and that youth's brains are not fully developed until they are 25, making them less culpable and more likely to grow out of behavior that leads to delinquency. We know that keeping kids out of the juvenile justice system makes it so they grow into mature, law-abiding adults, as opposed to higher recidivism rates that we've seen for kids who are in the system. SB 94 provides for kids who must come into the system and who do need services to have an assessment that will inform all of those needs and strengths of the youth and result, hopefully, in a more developmentally and individualized plan for the youth. The hope is through SB 94 and the collection of data that the racial inequities that are apparent in the juvenile justice system will be addressed. As we know, Black and brown youth are overrepresented in the system across the board, from the point of arrest to disposition and commitment to SYSC. For all of these reasons, the public defender supports the passing of SB 94. I support the passing of SB 94. Thank you.
Thank you. And did you have written testimony?
I'm sorry, I do not have written testimony.
Okay, thank you. Representative Long has a question.
Certainly.
Thank you, Madam Chair. And thank you for your due diligence on this. Thank you for your involvement.
Absolutely.
The applicability, is there a reason why it goes from January of 22 to July of 22 to October of 22 for different courts? Was there some reasoning behind that?
I think if I'm correct on this, and of course Joe can answer this better, but I don't think he's still here. But the idea was that this is a lot to implement. It's going to take a lot of details. And so the thought was that we would implement it slowly and we would start in one place to the next. And really it's simply about implementation, to make it smooth. And frankly, I think the places that were contemplated were because there are heavy juvenile dockets. There are very involved juvenile judges in those areas, and they will be ready to take this on. And so then we'll figure out the kinks, and then when we get to the other courts, it'll be much smoother at that point. So I believe that was the primary reasoning for that.
Okay, thank you.
You're welcome.
I think that was a good reason,
Yes.
honestly. Are there any further questions? All right, seeing none. Thank you very much, Ms. Jones.
Thank you.
Up next is Richard Head. Please state your name, where you're from, and if you have written testimony.
Thank you, Madam Chair. Thank you, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the New Hampshire Judicial Branch. I don't have anything specific to say other than we support the bill as written. We apologize that Judge Ashley had a family emergency and was unable to participate in both this and the prior hearing. But if there are questions, I'd be happy to try to research them. But we just wanted to say we support the bill as presented. Thank you. I'd be happy to answer any questions, or at least try to, in Judge Ashley's absence.
Okay, are there any questions for Mr. Head? All right. Oh, Representative Long.
Thank you, Madam Chair. Just it would be helpful because I'm looking at the Aquavit when they go into an event, and I see Manchester has one of the last ones, which is okay. But I'm wondering, Mr. Head, if you would have case numbers. I mean, the amount of cases in the 9 circuits, because I'm thinking maybe that's why they separated it too, because I see Nashua has one of the first, so there's probably a lot of caseload there. So would you have that by, I mean, not today, but could the committee get that breakdown?
I can certainly see what I can get for you and get that to the committee. We do also have some number of statistics on our on the website, so it may just be publicly available too. But either which way, I will get you either a link or the data regarding number of cases.
Okay, thank you.
Representative Long, if you like, I can see if Director Ripson can come back on so he can answer that question for you.
Yeah, that'd be great, because I don't even know if they can get a number because this is unique. They got to agree to assessments and all that stuff. So
okay, so are there any further questions for Mr. Head? Okay, seeing none. Thank you very much, Mr. Head. And I'm going to call Director Ripson back up so that he can address Representative Long's questions.
He is unmuted.
Yeah. You are unmuted, Director.
Great, thank you, Madam Chair. Yes, I don't have the exact numbers in front of me, although probably in 5 minutes I could pull up some numbers. I just have to go into our data system. But yes, the part of the rationale for the rollout was, as Ms. Jones explained, one, having appropriate time to implement it in different places. Part of this is we're shifting the role of some of our staff. So staff who historically have only done probation and parole oversight for open court cases are going to move into this new role of doing these assessments up front. And we're counting on the reality that we're going to have fewer deep end cases, meaning we have more workforce to do the front end work, right? So we have to move it over time so that we can shift staff from one end of the system to the other end of the system. And then, so that was the reason why we had to implement slowly over time. I mean, it's not that slowly, it's over, I think, 3 different quarters. But then the choice of where to set that up was based on making sure of a couple different things. One, that we weren't overwhelming the system by having, the 2 biggest parts of the state combined at the same time, which would be, as you alluded to, Nashua and Manchester. And 2, the places where it seemed like we had the easiest, choosing for the very first one, the places where we seemed that we had the easiest collaboration between public defenders, prosecutors, JPPOs, courts, who were kind of naturally on the same page around this, so that we can kind of test it out with them, work out the kinks with them before we rolled into other places where maybe those relationships weren't quite as strong yet. So those were the reasons. Although like I said, at the end of the day, I think this is going to be good for everybody. But we tried to structure it in a way that it would be successful and didn't just open up the doors and not be ready for it.
Okay, great. Thank you so much. Does that help you out, Representative Long?
It does immensely. Thank you.
Great, thanks. Okay, up next is Moira O'Neill, the Director of the Office of the Child Advocate.
Thank you, Madam Chair. Thank you, committee, for hearing my testimony. For the record, my name is Moira O'Neill. I am the New Hampshire State Child Advocate, and I am happy to support Senate Bill 94 relative to juvenile diversion programs. I am also a member of the Juvenile Transformation Team. And just to give you a little context, since we all went together to Washington, D.C. pre-pandemic for an entire week, the most intensive week of my life of training and education, we have been meeting sometimes 3 and 4 times a week since then, working on this project. And it's been a phenomenally interdisciplinary process. And we've come to really appreciate both each other and the commitment for this, for the broader transformation of juvenile justice. So very pleased to be able to support this bill. And I just want to emphasize a little bit that Senate Bill 94 is about prevention. It provides for a child to obtain this voluntary strengths-based needs assessment before the petition is filed. And just to give a little context, when a child breaks a law or a rule, there are potentially 4 conditions. One, it may be youthful indiscretion, which is more about immaturity than criminality. There may be developmental disability or mental illness, which is about disruption in development or an illness and a resulting incapacity for the insight about what the child's doing. There may be adverse childhood experiences in which children's actions are influenced by the adverse factors of their lives, such as poverty, hunger, exposure to substance abuse, and family dysfunction. And there may be a social pathology or an intentional criminology, which is actually fairly rare amongst young children. So under Senate Bill 94, a police officer can still address youthful indiscretion by counseling that child and sending them home to his parents. And for lessons learned. But for those children who are not immediately sent home, a disability or an adverse influence will be identified in this assessment process. And through that process, solutions will be sorted out to best help the child and the family, whether it will be clinical help, educational help, or perhaps some targeted social supports. And I want to emphasize that the purpose of assessing needs is to determine whether, if you mitigate that need, you can also mitigate the risk of the child's behavior towards the community. So this is essentially a sort of law enforcement effort, and that we're trying to make sure that when children's needs are met, so that they're not a risk to the society. And while probation may feel intuitively like it's going to stop problem behavior, what we've learned in the past 1.5 years is that it actually doesn't. And any involvement, in fact, in the juvenile justice system is a primary indicator of reoffending, of poor school performance, and of other negative outcomes. In fact, children who are diverted from the system are far less likely to be suspended from school. So when their needs are met, the incidence of reoffending is lowered. And this is consistent with what you've heard from me about children's brain development in past hearings. And Attorney Jones mentioned that brain development is in the context of culpability that children don't understand. But equally as important is the malleability of the child's brain means that they can learn and they can adjust their antisocial behavior in the right conditions. So we're trying to create the right conditions for these kids. And as you also know, and I think that Attorney Skibby mentioned about the majority of children coming into the system more not because of serious offenses, but because of a lack of understanding about their needs or the inability to access services. There's too many kids in the system who have mental health disorders identified. So this will address those without encumbering the system, quite frankly. Our office, the Office of the Child Advocate, encounters children regularly who could benefit from the proposed needs assessment in Senate Bill 94, and certainly from avoiding the system involvement that they're in once we've met them. Children themselves note that their parents need mental health or substance use treatment in addition to whatever their needs are. To your question, Madam Chair, about law enforcement objecting to this bill, one police officer recently told us in one of our affinity groups that children are better off in the juvenile justice system because their parents are so dysfunctional and unable to help them. And we know this isn't an effective way to do juvenile justice or child welfare, but it does reflect the reality that the police encounter on the street every day. So they actually may not even have a vision for what a child looks like when he or she and his family are being supported the way that they need to be. So hopefully we're going to be able to transform a lot of that thinking as this plays out. It's far more likely that a child will get back on track if their needs are identified and met, and the family is supported in a way that they can grow strong and gain capacity to manage their family's challenges. So yesterday, I had a conversation with a boy at the Sununu Youth Services Center who told me that what young people need, if they're old enough, is help getting a job. And then he said, if they're not old enough, it may be that their parents need help getting a job. And it's wonderful when you propose a need for a policy that a child actually confirms for you. And never underestimate how smart these kids are. So I suspect were he to undergo that assessment, that need in their family for employment, for family economic stability would probably be identified and we could address it. And he wouldn't be in the high end of the system where he is today. So for those reasons, I encourage you to support Senate Bill 94. And I thank you very much for taking my testimony. If you have questions, I welcome them.
Right, thank you. Representative Long.
Thank you, Madam Chair. Ms. O'Neill, are you aware of any police training with reference to this?
With reference to this bill?
Well, yeah, well, specifically the actions of this bill.
Yeah, so I think that Director Ribson did explain that that's been part of the work that we're doing. Okay. We've been having these gatherings, and we have some. We've reached out to, so far we've spoken to probably 500 or 600 people on this issue. Many stakeholders, many people who are interested. And if you attended the affinity groups, you know that we actually went into little meetings with folks like a focus group and had their opportunity to share information with us. And now we have 4 more convenings coming up where we'll go a little bit more deeply into this and continue those conversations. That's really is an important piece of it, to be able to engage, especially law enforcement, prosecutors, the people who are encountering these kids every day, to be able to understand what the changes will be.
That's great. Thank you.
Thank you.
Okay, are there any further questions for Ms. O'Neill? All right, seeing none, thank you very much.
Thank you, Madam Chair, and I did submit written testimony. You should have it. I sent by email. Thank you.
Thank you so much. Okay, is there anyone else who wishes to testify? I see Mr. Head has raised his hand again, but you've already testified. I'll let you, if you wanted to add input to a question, but I really don't want to get into debate back and forth once testimony has been given. So Mr. Head, go ahead.
Thank you, Madam Chair, and I appreciate that. I was just wanted to loop back on Representative Long's question regarding the numbers. If there were, I did manage to find it and pull it up. And really what it looks like is the groupings are really to distribute them so they're not top heavy, so that we have sort of an even distribution of cases among the circuits as it's being rolled out, rather than just doing all light ones or all very heavy districts. They're really balancing the numbers throughout the various districts so that they can be rolled out evenly.
Excellent. Thank you so much for that.
Thank you, and thank you for letting me come back on.
Okay. All right. So that's it for Senate Bill 94. I will tell you that 14 people signed in support, 27 in opposition, and I will close the public hearing on SB 94. I'm going to give the clerk a few minutes and give everyone a few minutes to get their cameras on so we can go ahead and go into executive session for SB 94. So we'll just go for 2 minutes. Just let me know when you're ready, Madam Clerk.
Who do you want to? Good. Yeah. I'll second it.
Okay.
You do the committee report too.
That's what, when you make the motion, you make the.
Madam Chair?
Yes.
Is the Manchester Police on the opposition, do you know?
I did not see them. The one I noticed was the New Hampshire Chiefs of Police, I think it was.
Okay.
The New Hampshire Association Chiefs of Police. What is your chief's name again? A lot of them came in with just names representing themselves, not even an organization.
Aldenberg.
Sure.
Alden what?
Aldenberg, B-E-R-G, Aldenberg.
Yeah, I don't see him on here.
Okay, no, that's fine. I just needed to know if I needed to talk to him or not.
Yeah, I don't see it. I know, I see one of mine on there, so I'm gonna have to give a call.
Okay, do you see anyone from Newport?
I do not.
Madam Chair?
Yes. Who is calling me?
Representative Altshuler, I'm going to take my hand down. Could you, before we begin the executive session, or as we begin the executive session, could you please read the names, the 14 in support and the 27 in opposition from the blue sheet or the sign-in sheet, whatever we're calling it now?
Read their names?
Yes, please, because we can't see it.
Okay.
It was emailed to us this morning.
You should have it in your email.
Oh, there's an email with it? Okay, let me check that.
Christina Dyer sent it out this morning.
Thank you. I'll go take a look.
If not, perhaps Christina could send it out again.
No, I see it.
Okay, good.
Madam Chair, I'm ready when you are.
Actually, it doesn't say who signed. It just says that people signed. The only thing I have in this email is who's signed up to speak, not the people who signed in support or opposition.
Don't have the list that goes below where they signed up?
Nope.
Christina?
Yes, so there should be the numbers at the top of the page.
Right. I see that.
You want the full list of the people?
I just want to hear who signed in support and who signed in opposition before we
Okay.
begin. the executive
I will
session.
send that to you right now.
Thank you.
You're welcome.
Oh, thank you. All right, I'll watch my email.
Could it be sent to the entire committee? I don't know if that.
That was what I was hoping she was going to do.
Thank you. Yes, absolutely.
Well, Madam Chair?
Yes.
Yeah, I mean, as far as I'm concerned, I already know where I am with this bill.
Yeah.
And I'm positive on it.
Yeah.
I needed to know who so that afterwards I could call them. I certainly understand the uncertainty of opposition from law enforcement.
Yep.
However, with training or whatever, I don't think it's going to be an issue. So I don't know if the committee needs that list prior to execting. Or, I mean, I just want to see whose names are on that. So I'm going to give them a call after we exec.
Right, because I think that it's, again, the fear of the unknown maybe and the change, which is something, we have to get used to because clearly what was being done before really isn't working in the best interest of the kids. So, we have to be able to spread our wings and try new things. So I'm going to ask Representative Litchfield, Representative Yokella, can you turn your cameras on if you're going to vote for an exec session? Okay. All right, so I'm going to go ahead and open the executive session on Senate Bill 94.
Cody, turn your camera on.
Representative Belanger. He doesn't have to, he's in the room.
You're right.
But I will.
Representative Belanger, do you have a motion?
Yes, Madam Chair, I make a motion, SB 94 be OTP.
Second.
Seconded by Representative DeSimone. Would you like to speak to your motion, Representative Belanger?
As reformed youth, I think this bill does an excellent job in moving away from a one-size-fits-all approach, which is kind of where we are currently. That is why I support this bill, and it's important not to pass motion.
Is there any further discussion? All right, well, seeing none, I will have the clerk call the roll.
Thank you, Madam Chair. Vice Chair, Representative DeSimone.
Yes.
Madam Chair, Representative Rice.
Yes.
Representative Yokela.
No.
Representative Lewicki.
Yes.
Representative Belanger.
Yes.
Representative Litchfield.
Yes.
Representative Smith.
Yes.
Representative Long.
Yes.
Representative Ali Sayed votes yes. Representative Grossman.
Yes.
Representative LeVesque.
Yes.
Representative Wazir.
Yes.
Representative Petrino.
Yes.
Representative Altshuler.
Yes.
Madam Chair, we have 13 yeas and 1 nay.
Will there be a minority report, Representative Yokela?
No.
Do you object to it being put on consent?
No.
Okay, so without objection, SB 94 will be placed on the consent calendar. Okay, folks, so I'm closing the exec session on SB 94, and that seems to be the end of our business. So I want to thank all of you so much. I really, truly appreciate all of you, the time, the effort, the work, the great questions, everything. And we can look forward to our next term when we start meeting again. And we'll see you all at the next House session. So everyone, please have a great day. Thanks so much. Bye-bye.
Thank you. Bye-bye.
Christina, can you put the feed for me?
I'm sorry, could you repeat that?
Can you cut the feed?
Absolutely.
Thank you.